Today, the format is a little different. We have 3 papers presented. I've been instructed to instruct the paper presenters that they have between 5 and 10 minutes to present their papers, and no more. 10 minutes, okay, well, that's between 5 and 10. And then Jack Balkin will have 20 minutes to respond, and then the paper presenters may take 3 to 5 minutes. Is that right, Mike? 3 to 5 minutes to respond to Jack or to each other. And then in the time remaining, which will be brief before we break, I'll start taking a cue, and then the conversation will continue after the break. So I think we'll take the papers in the order that they appear on the program. So that the first paper will be that of Kurt Lash. Kurt, clock is ticking.
Okay. Doesn't have to wait till the ball is actually touched when you come in bounds. Thank you, Larry. It's good to be back at another wonderful conference on originalism. My thanks to Mike Ramsey, Mike Rappaport, Steve Smith, Don Dripps, a whole gang here at USD for the latest in a series of really substantive talks about constitutional theory and constitutional history. Now, somehow on those occasions when I've had the honor to speak, it's generally been about some exceedingly obscure text in the Constitution or an even more obscure aspect of constitutional history. So, for example, it could be on the Ninth Amendment, or maybe on the Privileges or Immunities Clause. This year it's Resolution 6 of the Virginia Plan. And as has been the case in all prior years, the text that I'm going to be discussing has pretty much no chance of getting the attention of the Supreme Court of the United States. It's just that this year I actually am rather happy about that. In brief, the paper addresses history-based claims by a number of scholars that Article 1, Section 8 ought to be read in a manner that perfects an expansive understanding of Resolution 6 of the original Virginia Plan. And in the paper, I argue that there's no historical basis for relying on Resolution 6 as a guide for understanding the scope of federal power under Article 1, and that claims to the contrary are based either on historical mistake or on miscritical historical evidence to the contrary. So what I'll try and do to be within my time, just give you kind of some context behind Resolution 6 and what my historical arguments are. As many of you already know, when the Virginia delegates arrived in Philadelphia, they got there a little bit early, and they got together and crafted a series of proposals that they hoped would guide the convention away from simply tinkering with the Articles of Confederation, and instead would move the convention more towards the creation of a brand new national government. Resolution 6 of this so-called Virginia Plan allowed Congress, quote, to legislate in all cases for the general interests of the Union, and also in those which the states are separately incompetent, or in which the harmony of the United States may be interrupted by the exercise of individual legislation. That's Resolution 6, at least in its final form. After adopting the resolution, the members sent the matter to the Committee of Detail, who then replaced Resolution 6 with a familiar list of powers that you get in Article 1, Section 8, and from that time forward, Resolution 6 was never heard from again. It's not discussed at any additional time in the Philadelphia Convention. It doesn't appear in the ratification debates, and in fact, prior to the 20th century, no court, no constitutional commentator ever indicated that Resolution 6 had any relevance at all to the understanding of Article 1, Section 8. But despite that fact, despite its omission from the text, despite the relative historical obscurity, recently a number of scholars have argued that Resolution 6 actually ought to serve as a guide for the proper construction of federal power. And obviously the most influential Resolution 6 advocate is here with us today, Jack Balkin. And he's claimed that Resolution 6 was the animating purpose behind Article 1, Section 8, and that the purpose of enumeration was not to displace the principle, but actually to enact it. So accordingly, commerce is among the several states when the states are severally incompetent to deal with a particular issue, or the harmony of the United States may be interrupted by the exercise of individual legislation. He also insists that because all of Congress's powers were designed to realize the structural principle of Resolution 6, they inevitably must overlap to ensure that the new government would have power to legislate in all areas where the states were severally incompetent. Now, it's not just Jack. A number of people, a number of scholars have made similar claims about Resolution 6, and they all are based on various normative theories of constitutional construction, but all of the advocates claim that the resolution reflects either the original intention or the original purpose of the framers, and that it was publicly announced as such by James Wilson during the Pennsylvania ratification debates. Now, obviously, my paper challenges Jack's historical evidence on a number of grounds, but as I was talking with Jack yesterday about this, I really think my major argument is not so much with Jack as with a number of scholars who are relying on his work. For example, even if I'm right about the history that's in the paper, I'm not sure that that's necessarily fatal to Jack's particular project of text and principle. I think it would give him some problems, but I still think that it's possible that he can arrive at his conclusions without necessarily relying on specific arguments of original intent or original public meaning. And that's an important point because I think so many scholars have actually relied upon his work and understood his work as actually making claims that are based upon original intent or the original public understanding of the Constitution. I think that's true for Andy Koppelman. I think Cooter and Siegel make that assumption about Jack's work. And obviously Barry Friedman is making that assumption, not only in his Dormant Commerce Clause piece he just came out with, but in his numerous amicus briefs in the ACA litigation. And if scholars of that caliber are reading Jack's work as establishing arguments of original intent and original meaning, I think others are likely to do so as well. So really, if you think about it, by my explaining why the historical record provides no basis whatsoever for tying Resolution 6 to the original intent of the framers or to the original public understanding, I'm actually helping Jack out by helping to clarify what must be the ultimate basis of his claims. Now, as far as what the history, the historical argument's fairly detailed in the paper, again, just to trace them. Although the framers may have used Resolution 6 as a kind of placeholder prior to the drafting of Article 1, Section 8, there's no evidence that they actually intended Article 1 to enact the principle of Resolution 6. And in fact, I think there's evidence that they understood Article 1 as not perfecting or relying upon Resolution 6. I think that's especially clear after the rejection of Madison's proposal to grant charters of incorporation where the interests of the United States might require and the legislative provisions of individual states might be incompetent. If the framers had understood Article 1, Section 8 as allowing Congress to act in all cases involving the national interest to which the states are incompetent, then Madison's proposal obviously wouldn't have been necessary. Instead, the members clearly did not believe they'd granted Congress power to act, in all cases where there might be a collective action problem of national importance. And not only that, none of them mentioned Resolution 6, despite the fact that Madison's proposal actually used the language of Resolution 6. Instead, they rejected the idea that Article 1, Section 8 had actually already authorized congressional action in all cases involving a collective action problem of national importance. Now, a lot of that part of the paper, of course, deals with original intent. That's going to be of only limited interest to many originalists. Most of us focus on original public meaning arguments. And in fact, what got me interested in this project to begin with weren't so much claims about the framers as the claim that Resolution 6 was actually discussed during the public ratification debates, in particular that it was mentioned by James Wilson in the Pennsylvania ratifying convention, and the claim that James Wilson had actually linked Resolution 6 to the meaning of Article 1, Section 8. The problem is, and again, as I trace through the paper, it appears that Wilson wasn't talking about Resolution 6 at all. The principle that he's reported as describing in that convention is a mirror image of a principle that Roger Sherman had unsuccessfully proposed in the convention. Wilson had stated at that time that he liked Sherman's proposal. He actually thought it was better than Resolution 6. He thought it was a better principle for the understanding of federal power. And so in the Pennsylvania ratifying debates, it's clear that he simply returned to a principle that he thought was better than Resolution 6 all along. Now, I'm aware that you can read Wilson's speech, and you can read Sherman's proposal, and you can read Resolution 6 at a high enough level of generality so that you can make them all pretty much say, essentially the same thing. But what we're considering is whether or not the framers in general, and James Wilson in particular, viewed all these principles as meaning the same thing, because that's the only way that you could actually claim that Resolution 6 or its equivalent was actually discussed and publicly addressed during the ratification debates. But here I think the evidence is fairly clear. Neither Wilson nor anyone else thought that they were dealing with the same principle. Wilson certainly did not, and the convention obviously did not, because they rejected Sherman's principle in favor of Resolution 6. I also talk about how there are actually two versions of Wilson's speech, which actually I think is kind of fun, but there's no reason to go into that right now. I just want to say that in conclusion, what Wilson believed or what he didn't believe or what he said or what he didn't say is of only limited importance. Again, what we're after is what was the public understanding of Article 1, Section 8, and whether or not the public would have linked it to Resolution 6. And I think the answer here is clearly no. So in the end, Jack could be right that Resolution 6 might best represent what ought to be our law. My paper maintains only that Resolution 6 was not their law. Thank you.